Good evening. Welcome to Legal Talk, the talk show brought to you by the law offices of O'Donnell, Weiss, and Megay. Your life, your business, your law firm. My name's David Megay, and I'm an attorney with the firm. And tonight I'm joined by Joe Koury to my immediate left, Gary Stein to Joe's left. Guys, thanks for joining me tonight.
Thank you, dude.
Folks, O'Donnell, Weiss, and Megay, we're at 41 High Street in Pottstown. We're at 347 Bridge Street in Phoenixville. And guys, this is our 60th year.
Correct.
We're taping this in
For April.
April. Yeah, there you go. April of 2015. It's our 60th year this year. And tonight, folks, we're going to talk about something Gary generally called restrictive covenants. And it should be a topic that should be interesting to all of our viewers who are employers, as well as those who are employees, maybe in a sales field or a field that where they may have signed a non-competition, non-solicitation, trade secret, restrictive covenant type of agreement. And we're going to look at it, folks, from two standpoints, from the employer side and from the employee side. And then, Gary, I teased it a little bit, but generally there are, I think, three general types of restrictive covenants.
Yes, that's right, Dave. First, and probably the covenant that's most commonly known is called a non-competition covenant or a non-compete. The idea there is that a party that leaves an employer agrees not to compete with that employer for a certain time period and in a certain geographic area. So that's the basic concept behind a non-competition agreement. And as Dave mentioned, there's also non-solicitation agreements where the former employee would agree not to solicit customers of that former employer. And the third is called a non-disclosure agreement, which is where the former employee agrees not to disclose certain confidential information or trade secrets. So briefly, those are the three kinds of covenants that we're going to discuss tonight.
Hey, Joe, that non-solicitation, which I think was the second one Gary talked about, Gary mentioned that I'm your employee, I get hired by you, you have me sign a non-solicitation agreement. When I leave, I agree not to solicit your customers, but it's also solicit your employees as well. Have you seen that?
I have seen that. And generically, you could call that a non-poaching agreement. You agree not to, after you leave employment, go reach out and try and quote-unquote poach employees of your former employer to come work with you at your new place of employment.
Okay. Now, Joe, when are these agreements generally signed, and how does that work? I come to work for you today, you come to me a couple of weeks from now and say, oh, I need you to sign one of these restrictive covenants that Gary talked about. Is that one way? Or?
Well, that is one way, but that's problematic, as I'm sure we'll explore a little later in tonight's program. Mm-hmm. Ideally, from the employer's perspective, these types of agreements are part of the hiring process and are put in place at the beginning of the hiring process, and certainly should be part of the application and hiring discussions if the employer wants to be on the most sound footing.
That makes sense, because there's the employer has an interest that it wants to protect, being its intellectual property, trade secrets, customer list. But yet isn't there a disparity or a unfair bargaining generally between the employee and the employer?
Well, that certainly is the policy argument, if you will. It's a balancing of competing interests. The employer wants to protect its investment, so to speak, in the employee, as well as its proprietary or confidential information and the like. And on the other side, the employee obviously wants to be able to perform his or her trade freely and to better their lot in life, so to speak.
Right. The three of us were at an event last night where Gary mentioned that very thing about it's a balancing act, Gary, between protecting the employer and protecting the employee. I mean, how many times have you heard, both the three of us have heard, I'm going to ask Gary though, non-competes are not enforceable because you can't stop me from earning a living.
Yeah, I mean,
It's kind of a
first,
urban myth.
First, that's not true
Mm-hmm.
because a properly done non-compete is very enforceable because it's a binding contract between two parties.
Mm-hmm.
And you're right, there's a balancing test here because on one hand, the effect of non-competition agreement in particular can be to restrict the former employee's right to earn a living. That's a pretty serious restriction.
Mm-hmm.
And that's why in Pennsylvania, the two most important aspects to any non-competition agreement are time, the duration of the restriction, meaning how many months or years, and then the geographic radius that's applicable to it, and basically what kind of geographic limitation this former employee has in terms of restricting his right or her right to earn an income.
Mm-hmm.
With respect to time in Pennsylvania, the norm is 2 to 5 years. 2
Okay.
is more in the nature of an employee that has just worked for this former employer, may not have been involved in management, was not an owner of the enterprise. And then we go out as far as 5 years. That would certainly be applicable to an owner, majority shareholder in connection with the sale of the business or the majority of the stock in the business or somebody that has very specialized knowledge. The idea is that party could actually compete with the former employer and cause economic injury to the former employer. That's what the non-competition agreements are designed to protect, is that risk of harm to the former business.
Right, right. Now, Joe, I was just thinking of this. Maybe it's off topic or off the schedule, but you mentioned, or maybe I mentioned, that the purpose is to protect the legitimate business interest. And I was thinking of this while Gary was talking. How many times have we seen an employer come to us, an employer client of ours, come to us after a key employee left, and they approach the whole analysis as a means to punish that former employee versus to protect a real legitimate business interest. And it's our job as attorneys to dig into that, to that employer client and say, now wait a minute, are we protecting a legitimate business interest, or are we really just out for a little revenge?
Yeah, occasionally, unfortunately, you will see the
Does
employer that will use
Yeah.
the non-competition agreement as more of a stick, so to speak.
Or a hammer, yeah.
Or a hammer.
Yeah, whatever, yeah.
Than anything else. But Dave, as Gary was talking and as you were raising these points, it's important to realize how many, or the level of policy concerns underlying this whole discussion, frankly. We're talking about balancing interests, and it's important to know that Pennsylvania sort of takes a middle approach. And of course, we're in Pennsylvania. Most of our viewers are in Pennsylvania. Pennsylvania tries to balance the employer's legitimate interests and the employee's legitimate concerns. Other states are not as generous. In fact, some states will not allow non-competition agreements in any form, frankly.
Oh, wow.
So,
Okay.
something to note importantly for our viewers who may be here in Pennsylvania but have agreements that say the laws of another state govern, that may be something that would need to be explored by that particular employee.
Right.
If there were public policy considerations different in that state
Right.
than from Pennsylvania.
Okay. Let's talk a little bit about the where non-competitions. What kind of industries do you usually see non-competitions in, Joe?
Well,
roughly?
the
Businesses.
traditional industries were sales positions, and technology for obvious reasons.
Mhm.
We're seeing, and I know we've talked, Dave, in our practices, we're seeing more of a service industry. There's been a reach into the service industries, and by that I mean, and we've talked anecdotally about hair salons,
Yeah.
specialized manufacturing, just sort of non-traditional areas. Our employers are now seeking to impose non-competition agreements.
Yeah, where the salespeople are relatively transient, and you hire me, you introduce me to all your employees, you introduce me to all, more importantly, all of your customers, You pay me to work those customers, sell to those customers, and then I get poached by one of your competitors. When that competitor hires me, the competitor, my new employer, is hoping that I can go back to those customers that you introduced me to and take them away from you.
Exactly.
That's the classic scenario.
Right.
Gary, what about trade secrets and confidential information like customer lists? These restrictive covenants would and you hire me. What does it say about your customer list? You're telling me that if I work for you, if I leave, I can't take that stuff with me?
That's correct.
Okay.
The list itself, and it's kind of a fine line, because the fact is that a good salesman doesn't need a list to know who his customers are. You know, there's relationships there.
Right.
So it does apply to more than just the customer list. There's a prohibition against contacting, or should be a prohibition against contacting customers of the former employer.
Okay. But I can't take your special sauce ingredients with me.
Pricing formulas,
thank
those
you.
kinds of things.
Yeah, pricing. I'm not supposed to take that with me. It's in my head, but I can't take the paperwork with me, the electronic data with me, etc.
Or you also not disclose that type of information to your new employer to allow that new employer to thereafter undercut the previous
the
employer.
key is competition between the new employer and the old employer.
Right.
And really preventing a form of unfair competition.
Right.
So that's one of the legitimate business purposes that Joe mentioned.
Mm-hmm.
You're right. It should not be a situation where the former employer is just seeking revenge against the former employee. We're really talking about protecting parties from the misuse of their proprietary trade secrets, their confidential information.
Yeah, that's a great point, because the court's going to look for that. The court's going to want to know, hey, Attorney Stein, you're in here looking for an injunction. You're looking to enjoin your client's previous employee from working with a competitor. You better show me, I'm the judge talking to you now, you better show me that you have something to be really concerned about. You're not just trying to use this as a hammer to punish your former employee.
Correct.
Yeah.
Yeah. A lot of times, like a lot of things in life, in the business world, sometimes there's an emotional underlying element that really drives what the employer is seeking at the end of the day. I mean, anecdotally, if a former employee burns the house down on the way out, so to speak, then it's more likely that employer is going to take a vengeful position.
Sure, you get pride and ego involved, and pride and ego and litigation, they don't mix well. Or maybe pride and ego causes the litigation.
Exactly.
Maybe they do mix
They
well.
could drive that litigation.
That's right.
Too well.
That's right. Yeah.
Okay, guys, the second half of the show, we're going to talk, I think now's a good time to break. We're going to talk about how do you enforce these things, what you need to make these things, meaning the restrictive covenants, enforceable, and then we're going to talk about these restrictive covenants from the perspective of the new employer. So I leave you, Joe, and I go to work for Gary. What kind of due diligence should Gary be doing as my new employer vis-a-vis his new employee, Dave, and what kind of as to what kind of restrictive covenants I have with my old employer, and perhaps what kind of liability Gary can be stepping into by hiring me. So, folks, stay tuned for the second half of the show, please. You've been watching Legal Talk, brought to you by your law office, O'Donnell, Weiss, and Megay. Thank you. Stay tuned for the second half.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. Convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Welcome back to Legal Talk show brought to you by O'Donnell, Weiss and Mattei Law Offices. Your life, your business, your law office. This is our 60th year, and I'm David Megay. I haven't been there 60 years, but I sometimes feel that way. Folks, first half of the show, if you're just joining us, first half of the show we talked about non-competition agreements from an employer standpoint and from an employee standpoint. And I'm joined here tonight by Joe Koury to my immediate left, and then Gary Stein to his left. Guys, we ended up the first half of the show talking about talking about the general principles behind non-competition agreements, what they're meant to do, what they're meant to protect, the policy considerations, the balancing act between protecting an employer's business and also protecting an employee's right to make a living. I'd like to talk next, Gary, about we're in court. What's the law, or how does the judge analyze or evaluate the enforceability of that restrictive covenant? What are some of the factors that go into determining whether that employment agreement, non-competition agreement, is enforceable or not?
Well, the first thing is whether, in fact, there's a contract. Meaning a binding agreement between two parties. We talked earlier tonight about making sure that you do have that agreement between two parties. And then the question is, when is it signed and when should it be signed? The most common scenario is that it is signed when the employee begins working for the employer. That's the cleanest way, certainly from the employer standpoint, and it means that the employee is aware of the requirement right up front before he or she begins to work for this new employer. And there's a possibility that if the employee doesn't want to sign that agreement and be bound by that restrictive covenant, maybe that employee should go seek another job for another employer. But
Right.
At least we're talking about issues disclosed right up front. Now, let's assume that is not done, and instead, after, say, a period of 2 years, the employer comes to the employee and requests the employee to sign that non-competition agreement. Public policy gives the employee certain rights in that circumstance. Because that's a new employment, a new term and condition of employment, at least in Pennsylvania, the law is that it has to be accompanied by new consideration. That means money or property bestowed or transferred to the employee. The idea is the employee is giving up a certain right, relinquishing a right, and should be compensated for that relinquishment of the right.
That's the consideration.
Exactly. The transfer of money or property to the employee at the time this agreement is requested. Because, as I said, it's really a new term of employment. And if that consideration is not paid, then in Pennsylvania, that non-competition agreement will usually not be enforceable.
Okay. How about continued employment? It's not good enough, is what you're saying.
Not in Pennsylvania.
Okay.
Because Pennsylvania is what's called an at-will employment state,
Right.
Meaning you're really not guaranteed employment. You can be terminated for any reason or for no reason at all, basically.
Right.
And the fact that you are continued to be employed as an at-will employee is insufficient in Pennsylvania as a matter of public policy for the consideration element for the non-competition agreement.
Okay. Joe, I come to work for you. I'm in sales. My territory is Montgomery County.
Okay.
Period.
Right.
You present a non-competition agreement or employment agreement with non-competition provisions in it, prohibiting me from working for 2 years after I leave you
Okay.
in the Tri-County area. Can you smell a problem with that?
Well, I think arguably that's an unenforceable agreement because of the geographic scope. Gary alluded earlier to two restrictions or concerns. A temporal one, meaning the amount of time of the post-separation restriction, and a geographic one. So in
Delaware Valley's not that. I mean, it's big, but it's not that big.
But
so
in
how could that be a problem?
In your example, you only functioned as an employee within Montgomery County, and here your employer is seeking to enjoin you or prohibit you rather from working in places other than Montgomery County. So that,
right,
to me, doesn't match up. It's not apples to apples.
That makes sense, because really, what do you? I could see that you want to protect your Montgomery County customers from me going to a competitor, but I've never talked to your Chester County, Delaware County, Berks County, Bucks County,
right,
Philadelphia County customers. So really,
right,
what's there to protect?
Well, again, probably nothing to protect. The employer might say that, in your example, well, Montgomery County is really not that distant from Chester and other counties.
So they could maybe make an argument. Now, couldn't the court, Gary, look at that agreement in that scenario where my non-competition with Joe says Montgomery County, or my sales territory is Montgomery County, but the non-competition says the 4 surrounding counties. Could the court not just throw out the non-competition agreement, but limit its enforceability to Montgomery County?
Yeah, I think the court has some flexibility here, and the court would be sitting as a court of equity in this situation, because normally the way these covenants are enforced are, first, the former employer would apply to the court for an injunction, and that's an order that would restrain the former employee from doing certain things. And sitting in a court of equity, a judge is supposed to, what we say is do equity, meaning be fair to both sides, fashion a remedy that's fair. So yes, I think that the judge, viewing the situation as a whole, might be in a position to fashion a remedy that's fair to both sides. In your particular example, I would say that there would be a non-solicitation against former customers in Montgomery County, not against activity in the surrounding counties. But then I think if you also had non-disclosure agreements, you'd look at that, and maybe you'd enjoin the former employee from disclosing certain trade secrets or other confidential information, even to potential customers in the surrounding county.
Sure, that makes sense. Let's turn things around a little bit. I worked for Gary. I had that competition agreement, the 5 Delaware Valley counties, but I only ever worked in Montgomery County. I leave Gary and I want to come to work for you. Either you recruit me or however.
I'm the new employer.
You're the new employer, and you're interviewing me, and you want to hire me. What should you do as a new employer, and what should our employer clients out there or viewers out there be thinking of when they interview somebody?
Well, I think at a minimum, it's certainly fair for an employer to inquire about any past non-competition agreements, particularly within the last 5 years, because as Gary mentioned, that's sort of the outside time restriction on restrictive covenants in Pennsylvania, at least. You may also require certification as part of the actual application that I either am or am not subject to or party to or ever signed a non-competition agreement. I think that's best practices is to explore that as part of the application and hiring process.
Okay.
Because the reality is if you don't explore that up front and there is a non-competition agreement of some fashion in place, not only is that now new employee likely to get a lawyer letter, so to speak, down the road
from the previous employer,
so is the new employer likely to get at least a lawyer letter saying your new employee is subject to this agreement, he's your employee, you have oversight, and you're in trouble too, so to speak.
How could the new employer be in trouble? The new employer had never signed a contract with the old employer under some kind of interference with contractual relationship argument or something.
That's actually a separate element, separate thing,
okay.
But very much so. The employer could be caught in that context, so to speak. But certainly, at a minimum, the new employer getting the letter would be what I'll call litigation technique. It may not really, at the end of the day, have merit.
Right.
But it's enough probably to scare that new employer that the new employer may just terminate the new employee, and the former employer has accomplished at least one of its goals in that case.
And again, I keep saying this, but I think it's pretty darn important. So long as that former employer's goal is not to punish the old employee, but to protect the former employer's legitimate business interest.
Correct.
Makes sense.
Yep.
Okay. If you're the new employee or employer, potentially the new employer, have you heard of that the new employer contact the old employer and maybe buying out the non-competition?
Yes.
That's probably fairly rare, but it could happen.
For the right employee, the gotta-have type of employee for whatever the particular situation is, that may be a smart business decision for the new employer to essentially assist in the buyout of that non-competition agreement, so that that new employer can go forward without the interference and minimum noise of the former employer with its business operations.
Yeah.
But the key place to begin is with making sure that the new employer knows whether or not the employee is subject to any restrictive covenants. Seems to me you start there.
Right.
And if that new employee is, and the employer really wants that employee, then you move forward analyzing the restrictive covenants and analyzing the possible courses of action. But the last thing a new employer wants is to be sued and dragged into court involuntarily just because they hired a new employee somewhat innocently.
Right. Right. This is we have only a short period of time, but like a minute. But it just occurred to me while one of you were talking. We've been talking about geographical scope, and it's got to be reasonable, and talked about county. But I've seen, or counties and that type of thing. I remember back in the day we used to put a pin in a map and take a thread out and do a radius around a particular office. That was before Google Maps and stuff, a particular address on a map. But I've seen non-competition agreements have nothing to do with a geographical scope, but instead be limited to a customer list. That I work for you, Joe, and I work these 5 customers, and only these 5 customers. I've seen non-competition agreements say, Dave, you can open up, if you leave me, says Joe, you can open up a shop right across the street and compete all you want, but you can't solicit those 5 customers. I guess that would be that's a non-competition, but more of a non-solicitation agreement.
Right.
So it's not geographical scope, not geographically oriented scope, but more of a customer list scope.
Yeah, but what you've described, I'd say, is a pretty fair former employer.
Pretty fair former employer.
Somebody that's being very fair to its employees and its prospective former employees.
Okay. All right, Joe. Gary, thanks a lot. We're at the very end here. I appreciate it very much. Folks, restrictive covenants, employment agreements from employer perspective and employee perspective, give us a call. We're happy to help. You've been watching Legal Talk, brought to you by O'Donnell, Weiss & Matei Law Offices. Your life, your business, your law firm, our 60th anniversary. Please contact us or please look at our website, owmlaw.com. We're happy to help. Have a great night, folks. Thank you.